Good afternoon and welcome, everybody. At DW Professor Lawyers, I thought it was appropriate, bearing in mind our contacts in the industry, to put on a series of seminars directed towards medical practice. We intend to provide 3 seminars over the coming months. One directed towards payroll, which Daniel's kindly agreed to deliver today, and we will be doing separate seminars in relation to risk management and employment in the coming months. So today's talk is about payroll tax in medical practices, and of course, as you would all be aware, it's a timely seminar to be presenting, bearing in mind the existence of the amnesty, which comes to the end of months. So without further ado, Daniel is going to take over and give the seminar today. Thank you, Daniel.
Thanks, Ben, and thanks all for coming. I'll be speaking to these slides today. They're pretty comprehensive. I will make a version of these available to you after the session. I just need to update them to reflect some necessary cross-referencing the time. Well, there we go. So I thought I'd just start before delving into specific aspects of the payroll tax regime that are relevant to and impact benefit clinics, just to do a brief overview of payroll tax. So it's the state-based tax payable by employers on all taxable wages. Taxable wages are paid or payable by an employer for or in relation to services performed by an employee that are taxable in South Australia. Wages can be exempt from payroll tax. I've given some examples there, but that's beyond the scope of this seminar. Importantly, liability for payroll tax doesn't kick in until the employer's aggregate taxable wages, including interstate wages, exceed the threshold amount, which is currently 1.5 million. Taxable wages aren't just wages or salary. There's a range of other things that can be taken into consideration. Rates of tax there as well. So when we're looking out whether payments of taxable wages, we need to know who are employees. There's no definition of employees in the Payroll Tax Act, so we revert to the common law employer-employee test. It's traditionally was a substance over form approach. There's a specific revenue ruling which I've cited there, PTA 038, which is called determining whether a worker is an employee, though that might need to be updated and amended in view of some developments to the case law recently, which I've listed below. Within that ruling, they cite some factors that are considered by the courts in determining whether a worker is an employee. You'd probably be familiar with most of them: control and direction, contract and practical relationship, powers of delegation, risk, and so on. Just in regards to practical relationship, we're looking at how the parties behave with one another. And I've just quoted from PTA 038 there, which touches on that practical aspect of the relationship. It says that it's necessary to consider all of the facts and circumstances of the relationship between the parties to the contract, including their conduct towards each other, both at the time they entered into the contract and after the contract has been executed. The reason I specifically cited that is there's been some recent developments in the case law which have put the emphasis back onto the contract as opposed to that practical relationship. So the cases are there, just abbreviating them, personnel contracting and ZG operations. And the gist of them is that you look at the indicia for classifying a worker as an employee or contractor as against the rights and obligations of the parties under the contract. You can still look at their conduct as between one another if there's some suggestion that this comprehensive contract is a sham or it's relevant to constituting some sort of variation to the contract. If we've got a common law employment relationship, then the wages come in as taxable under Part 2, Division 1 of our Payroll Tax Act. But if the answer to that is no, there's no employer-employee relationship, there's further steps to be undertaken to work out if the wages come in elsewhere. The first of those is the relevant contractor provisions. So working out, is the contract a relevant contract? If it is a relevant contract, as one of the exceptions or exemptions apply, they're designed to exclude genuine independent contractor relationships. If there's no exemption applicable, we've got the payments coming in as taxable wages under Part 2, Division 7. Lastly, we look at whether the amounts are paid under an employment agency contract, which is dealt with by Part 2, Division 8. I won't spend too much time on that because I'm not sure how applicable that will be to medical clinics operating under a simple contractor model. So this is section 32 of our Payroll Tax Act. I've underlined what from my perspective is key here. So this is from the perspective of the medical centre business. So we're looking at the business operated by the medical centre, and in the course of operating that business, they're supplied with services of another person for or in relation to the performance of work. RevenueSA has said in its recent ruling that from a medical clinic perspective, we're concerned with section 32(1)(b). That's why I focused on that and not subparagraphs A or C. Where we, the medical centre business, in the course of carrying on that business, have work-related services supplied to us. So what are the consequences of a contract being a relevant contract? We've got a deemed employer-employee relationship for the purposes of the Payroll Tax Act. But one person, typically the person receiving the work-related services deemed to be the employer, i.e. the medical centre business. I referenced there section 33(2). Look at these provisions, you'll know that they can be terribly confusing. And to that end, section 33(1) talks about where you're deemed to be the employer, and it says that if you supply services to another person, or you are supplied with work-related services of another, you are taken to be the employer. But what about in cases where you've got contracts that you've got services going both ways, which happens here with these sorts of contracts with general practitioners or other specialists, where they might be making their professional services available for people who are attending the services, attending the clinic, but in exchange you've got the clinic providing services to it. RevenueSA has taken the view that the correct approach is that the medical centre is taken to be the employer because it's receiving the practitioner's labour in the form of the medical related services. So we've got the person then performing the work, i.e. contracted medical practitioner being deemed to be the employee, and amounts paid or payable by the deemed employer for or in relation to the performance of work relating to the relevant contract being deemed to be wages. So the net effect is that we've got contractor payments being brought in as taxable wages upon which the medical centre business is being assessed for payroll tax purposes. The last dot point there, I put it in there, but I'm not sure sort of how applicable it's going to be here, but where you've got payments where a component of it's attributable to non-labour, that can be excluded from the amount that is treated as being wages paid or payable. So there's various exceptions to the relevant contractor provisions. If you've read the RevenueSA ruling, you'll know there's a focus on three specific ones, which are the ones listed there, and I'll talk to them in a little bit more detail later on. I thought I'd just draw your attention though to the last 3 dot points where you've got qualifications to some of these exceptions, or you've got a form of anti-avoidance provision. So we've got section 32(2)(c) there, which touches on the 2 or more persons exception test, and it says the wording is not ideal or as nice as it could be. It doesn't apply to a contract under which work is performed in a manner other than a manner referred to in that section, in addition to work performed in a manner referred to in that section, which is just lovely wording. The concern that I take from that is you might have a contract where there's various work that's to be performed, but what say some of that work is capable of being divided up into separate and discrete components of work, and so you've got some aspects of it being performed solely by a practitioner and then others where it's 2 or more people. Does that effect then mean that you can't rely upon that exception? That's my concern with 2(2)(c). 32(2)(d) is more of a general anti-avoidance provision, where you've structured the contract in such a way to avoid or evade the payment of tax by any person. And then section 47, which is geared towards payment for the services of a natural person under a relevant contract going to a related entity, such as a trust company or partnership. So the contractor provisions, as we've now come to know them, have been in the Payroll Tax Act since its commencement. I don't need to tell you why there's a significant focus for medical practices on this now. You've probably heard the phrases the optical superstore and Thomas and NAS to death. If you haven't, thank you, because we're going to do that again shortly. Historically, the view taken was that these contracted practitioners were independent contractors, and the contracts with medical centres under which they provided medical related services weren't relevant contracts because they weren't supplying any services to the medical centre, but rather supplying services to patients attending the centres and receiving services from the medical centre, i.e. administrative and support services, including fee collection services. And those recent decisions have turned that historical view on its head. So the optical superstore case, I thought it was just worth summarising some of the salient facts and the conclusions of the tribunals and courts in that, and Thomas and NAS, because they do really go to understanding the application and interpretation of these relevant contractor provisions. So optical superstore case first, we've got arrangements in the agreement being expressed as a landlord-tenant arrangement. We've got optometrists or related entities occupying consulting rooms on a non-exclusive basis granted by TOS as landlord. We've got optometrists undertaking eye tests for members of the public in the stores. We've got Medicare and out-of-pocket patient fees, which we call consultation fees, being billed by the tenant, but we've got payment going to TOS's landlord, who's acknowledging that these payments are held in trust for the tenant, and that became sort of a focal point of the argument in the optical superstore, but to be reimbursed in accordance with an occupancy fee formula, which was reflective of hours worked, times and applicable rate. We've got the balance of the consultation fees, if any, to be retained by the landlord as an occupancy, the GST to be paid, and there was contemplation that if the reimbursement amount exceeded the gross consultation fees, there'd be a separate payment to the optometrist, which was styled as a location attendance premium. That had a different complexion to these reimbursement amounts. Wasn't impressed with an express trust, and that led to some different findings in relation to those payments. So this is just reproduced from the RevenueSA ruling. the Victorian Civil and Administrative Tribunal found the contracts to be relevant contracts. TOS was supplied with services of optometrists for in relation to the performance of work. The services of the optometrist were provided to TOS as well as to patients. TOS receiving services in the form of the optometrist serving the needs of its customers. We've got some findings in relation to the tenancy arrangements not in truth being a tenancy arrangement more consistent with a contracting arrangement. I'll later discuss the distinction between medical centre businesses and businesses providing accommodation or administrative support services, because those distinctions find their way into the ruling, and really they involve a proper and detailed analysis of the business that's being conducted by the putative employer and the level of independence that the practitioner is applying in the conduct of its medical business. But it seems to me that RevenueSA has set a pretty low bar as to what arrangements it will regard as being a relevant contract. Interestingly, in the optical superstore case, the tribunal's decision that those contracts were relevant contracts wasn't actually challenged on appeal. The focus of the appeal was on these payments comprising trust distributions and whether that could be a form of payment under the Payroll Tax Act. So despite the findings in relation to the relevant contracts in the tribunal and on appeal to a single judge, it was largely a win for the optical superstore. Despite there being relevant contracts, the tribunal and the court of first instance found there was no payment for in relation to the performance of work, because the payments to the optometrists from monies the subject of an express trust was simply a return of monies to which they were beneficially entitled. The location attendance premium fee accepted because that arose in different circumstances. Those propositions were rejected by the Victorian Court of Appeal. I've just cited some of the important remarks from the court in relation to that, but the gist of it is that you can still have a payment under a relevant contract even where the recipient is beneficially entitled to those monies. When we've got the Thomas and Nars case, similar structural considerations to TOS. Taxpayer, the applicant conducting 3 medical centres in New South Wales, various doctors being contracted to operate out of those medical centres, each entering into a written agreement with the applicant. Under the agreement, taxpayers providing rooms at its medical centres, including shared administrative and support services, with doctors seeing patients at the medical centres and the patients paying the doctors directly for the medical services provided. Doctors are bulk billing each patient. Doctors had the option of dealing directly with Medicare to obtain the benefits that had been assigned to them or having the applicant do so. And all but 3 opted for the applicant to deal with Medicare in relation to those claims. And so you've got the applicant making those claims and receiving and holding those monies in a bank account specific to the clinic. And then you've got payments out to the doctors as to 7%, the applicant taking 30% as a service fee. So again, in this time in the New South Wales Tribunal, they've concluded that these arrangements are relevant contracts. I've listed there some of the terms of the agreements as between the clinic and the individual practitioners that the court regarded as being significant to the conclusion that there was a relevant contract. So you've got agreed roster commitments, you've got notice requirements and restrictions on the ability to take leave. You've got promoting the interests of the clinic, restrictive covenants, positive obligations to abide by operating protocols. So you've got sort of the effective research, you've got the clinic exerting forms of operational administrative control on these practitioners. The real kicker, though, is just underneath that. So the tribunal said the terms of these agreements secure the provision of the services provided by the doctors to the patients of the medical centres, and where such services were a necessary part of the centre's business, you've got doctors providing their services to the medical centre as well as to patients. And so I mean, what that suggests to me is that there's a focus on the business of the taxpayer and what are central aspects to the conduct of their business. Their big considerations and factors in working out whether we've got a relevant contract, and those sorts of factors have found their way into example factors in relevant rulings that have been released, particularly in Queensland in relation to when you're carrying on a medical centre business. So in relation to the relationship between the payment and the work, which is relevant to when amounts will be brought into the relevant contractor provisions and taken as being taxable wages. It can be a direct or indirect relationship. Here the tribunal found there was an indirect relationship because the Medicare rebates arose as a direct consequence of the performance of the medical related services. It is important to remember for the purposes of our section 35, which sets out when amounts paid or payable will be taken to be wages, there are relational issues and questions, not only as between the work that's being performed and the relevant contract, but as between the payment and the work that need to be considered. In NARS, the tribunal didn't really have to quiver with that, with those relational issues, finding that the work related to the relevant contract because it was expressly the subject of it. The agreement actually prescribing the sorts of services that the practitioners needed to render at the clinic. An important feature of this case is with the three doctors that contracted with the centre to process their own medical claims. So you don't have the medical centre business collecting those payments and then on paying them to those practitioners. We had no assessments by the Commissioner of State Taxation in relation to those payments. And I put here just some remarks from the New South Wales Court of Appeal where they dismissed the taxpayer's appeal. I'm not going to read them out verbatim, but one, we've got the administratively convenient approach adopted by the majority of medical practitioners meant that there was a payment made by the applicant to those medical practitioners, and so we've got the deeming provisions being engaged. And then just the underlying bit, the second dot point, as is clear from the position of the three practitioners who process their own claims for Medicare benefits, there's a ready mechanism to avoid that result, which is available. So where do these remarks, which relate to the flow of money, stand in relation to the third-party payment provisions under the Payroll Tax Act? It's thought to be a bit of a grey area, but a concern of mine is that where you've got payments that are coming from a third party to the deemed employer, would they get caught up in these third-party payment provisions? The answer to that lies in that if those payments had come from the deemed employer, would they be included as wages? Are they referable to the the services that the practitioner is performing? If the answer to that is yes, they can be taken as being wages, even though they've come from a third party. So the concern was the interaction between the third party payment provisions and what the Court of Appeal said in over to there. The Queensland revenue ruling on relevant contracts was reissued in September, and they address this issue, which I'll discuss later. So just turning to our ruling, PTA-SA 003, was issued on 30 June 2023. Contextually, we had Queensland's ruling coming out back in December 2022, so a bit of lag time there. SA is virtually a reproduction of that ruling. The stated purpose of the ruling, this is our SA ruling we're talking about here, says that it's not confined to general medical practices. You've got medical centre businesses being broadly defined. I've got some examples there that are underlined. I'll go on later to talk about the amnesty. As we know, the amnesty is specific to general medical practices, so you can understand maybe a bit of tension there. You've got a ruling that's not confined to general practices. They extend to other medical centre businesses, but those other medical centre businesses, whilst facing the same potential payroll tax implications, don't have the comfort of the amnesty to rely on. So naturally, they might be. This is just a reproduction of the ruling. From my perspective, it really sums up what it's about. I said before, seems to be the bar's being set pretty low. So we've got there will be a relevant contract if all of the following applies. Practitioner carrying on a business or practice of providing medical related services to patients. In the course of conducting its business, the medical centre provides members of the public with access to medical related services and engages a practitioner to supply services to the medical centre by serving patients on its behalf. The underlying wording is interesting as well. If a medical centre engages a practitioner to practice from its medical centre or holds out to the public that it provides patients with access to medical services of a practitioner, it is likely the relevant contract provisions will apply. And then if the contract provides expressly or by implication that a practitioner is engaged to supply work-related services to the centre by serving patients on behalf of the centre, we've got a relevant contract there. Significant comments to me. There's broad and conceptual observations as to what might result in a business being a medical centre business and a contract being a relevant contract. I won't get too caught up in this slide. So section 32 sets out when we've got a relevant contract. Section 35 deals with when amounts paid or payable relating to that contract will be treated as wages. This part of the ruling just in effect echoes the observations the optical superstore in relation to there still being a payment even where the practitioners might be beneficially entitled to the monies. And this is the section of the ruling in relation to third-party payments, which to my mind might create a little bit of a grey area as to whether, for example, payments of Medicare rebates and patient fees direct to a practitioner and not from a medical centre to a practitioner might still get caught up within that section. Ruling gives an example in relation to the operation of the third-party payment provisions, which is this. It's helpful, but it doesn't directly deal with that one aspect of the potential grey area that I just mentioned. Here we've got an interposed practitioner entity as opposed to the flow of funds going directly to the practitioner. So just working through that example, ABC is the medical centre. It's contracting with Dr. Wolf personally, who's serving patients on behalf of ABC. It's a relevant contract. Under those deeming provisions, ABC is the employer and Dr. Wolf's the employee. On the issue of payment, though, we've got bulk billed fees going to not to Dr. Wolf, but to his related entity, PICO, and PICO is then on paying 70% to Dr. Wolf and 30% to ABC as a service fee, and the effect of the engagement of the third party payment provisions is to treat the payment from PICO to Dr. Wolf as wages paid or payable by ABC. This is a recent development. Have many of you seen the updated Queensland ruling that came out in September? Actually address this issue. It's off the back of some comments by the State Treasurer in relation to the treatment of patient fees going direct to the practitioner and not being subject to payroll tax. This is just a reproduction of the table from that updated ruling. So if you look at the second and third rows from the bottom, these are the key bits. So we've got the first example, we've got Medicare benefits assigned by the patient to the practitioner and paid directly to the practitioner from Medicare. Is it going to be a deemed payment? No. And then out-of-pocket patient fees paid directly to the practitioner from the patient. That won't be deemed wages either. But where we've got a payment from the medical centre or from a third party to a practitioner entity and then to the practitioner, it will be deemed wages. I've read this ruling a number of times and I must say I'm still struggling to understand the reasoning behind it, but it is what it is. I'll get to it. Where I think they're coming from is where you've got this interposed entity that's then on paying funds. It's losing its character as being a statutory payment under the Health Insurance Act or as being directly paid by the patient for the provision of medical services, and then more susceptible to being a third party. So this is the rationale for these direct payments going to practitioners not being deemed wages. So where you've got the Medicare benefits being paid direct to the practitioner, it's not to be considered wages under 13E, which our equivalent would be section 35, because it's not being paid or payable by the deemed employer, it's coming from Medicare. And it won't get caught up in the third-party payment provisions because it's not consideration for the practitioner's services as an employee of the putative employer, because it's regarded as being a statutory payment pursuant to the Health Insurance Act. That's the key bit. So dealt with Medicare rebates. Now we've got out-of-pocket fees coming from the patients direct to the practitioner. This is 61 of the updated Queensland ruling. So again, similar rationale. It's not a payment under their 13E, so our equivalent section 35 is not coming from the deemed employer, and it's not consideration for the practitioner's services as an employee, but rather for the provision of medical services to the patient. So that seems to be the justification for saying in those instances those payments not deemed wages.
So I guess in that example, the medical practitioners then you pay a service fee back to the provider for use of the room or
Yeah, correct.
staff.
Yep, that's cool. So long as you've got payment going directly to the practitioner that's an individual practitioner as a sole trader, according to the Queensland ruling.
So you start incorporating.
Yep. On the same page. The other interesting part with that ruling is that they've now introduced as well an attachment 1. So previously the Queensland ruling and our SA ruling has those factors or indicia, the sorts of terms that might be in these contracts that are then being held to be relevant contracts. And so this is some aspects of what the court in Thomas and Nars touched on, so restrictive covenants and advertising, promoting the clinic and whatnot. Now you've got this attachment 1, which sets out factors in determining whether an entity is conducting a medical centre business. So you've got some usual terms that might find their way into agreements that might be relevant contracts, and also looking at the conduct of the entity and when it might actually be a medical centre business. I haven't reproduced it here, but I do encourage you to read that updated Queensland ruling, or just read the bits that I was talking about, because it's a 30-page document. But with attachment 1, just some of the things that I've highlighted here is, these are examples of things that might lead to a conclusion that an entity is a medical centre business. It holds out or promotes and advertises to the public as a place where medical services are available to the public. It's got a concern for patient dissatisfaction. The business is conducted in a manner to attract patients to the medical centre. Business operator retains control and ownership over patient records at all times. Commercial success and profit of the business is a function of the degree to which patients are attracted to the medical centre. The reason I've highlighted those sorts of things is it suggests that there's an approach that can be taken other than purely just looking at level of operational and administrative control that's exercised on the practitioners. So where you're promoting yourself as a place where medical services are available, and the success of your business depends on bums on seats, clients coming to the clinic to receive services, you could be caught up in being treated as being a medical centre business. At the risk of making this more confusing than it already is, there's the Employment Agency provisions as well in the Payroll Tax Act. I put them in here because our ruling does mention them. There's a revenue case in interstate one, Southern Cross Community, which provides some useful commentary and analysis in relation to equivalent or similar provisions. There was a thought bubble that maybe these provisions could apply to arrangements as between the medical clinic and individual practitioners, where in effect the clinic is the employment agent, it's procuring the services of another, i.e. the practitioner for a client of the employment agent being the patients. But the analysis in that case, and I'm happy to give you the citation if you want to look at it, suggests that that's a less concern, but they are what they are, and if those provisions are engaged, then amounts that are being paid to the service provider can be treated as wages payable by the employment agent. I won't speak to these in any great detail, but the ruling, our SA ruling, obviously distinguishes between relevant contracts and tenancies, and then relevant contracts and when you're dealing with an entity that's purely providing administrative services. So there's a distinction there. You need to closely analyse the respective businesses and who is supplying what services to who and working at. Is it a relevant contract, or in truth, a landlord tenancy arrangement, or you're dealing with fuel and administrative services business. That attachment one in that Queensland ruling that I referred to as well gives a comparison between some factors that are indicative of being a medical centre business and when it's a purely administrative business as well. So that's a useful comparison as well. Just in relation to the administrative entity, so it can be a relevant contract, but the other thing to be mindful of is the prospect for grouping, particularly based on use of common employees. I see smiles here, so people obviously familiar with that. I've just extracted here a ruling that's applicable to this, where you've got two or more professional practices being grouped by grouped with a service administration business, and in what circumstances the Commissioner will generally exercise its discretion to degroup. So it's listed there. I'll quickly go through the grouping provisions. In reality, we could do a whole seminar or a few of them if we wanted to today, but they're intended to combat wage splitting, so wages paid or payable by all grouped employers taken into account when assessing liability for payroll tax, by design very broad in their reach. And the Commission in some circumstances has a discretion to degroup, but not in relation to whether grouping arises from related bodies corporate. I'll just refer to that ruling again. These are the circumstances in which two or more employers may constitute a group. So we've got related bodies corporate, common use of employees provisions, so section 71, common control, section 72, and tracing of interest. So one is a controlling interest in the other under the tracing provisions in section 73. So can a member be excluded from a group? Yes, as they're very broad, the Commission has got a discretion to exclude employers. It needs to be satisfied that the business conducted by that member is independent of and unconnected with the business conducted by the other members of the group. Generally very hard to convince the Commissioner of that. There's factors that the Commissioner will take into consideration in determining whether to degroup, and then the prohibition on degrouping, where we've got corporations that are related under section 50. I've just made a note there, case of Eleanor Operations. It's a New South Wales case. I don't know if you're familiar with it. It's not specific to the medical industry. It had to do with managed investment schemes, but it is useful in that it runs through the grouping provisions and suggests the connection between the businesses needs to be material. So there needs to be a material connection. It can also be useful where the businesses involve holding monies in separate funds which are subject to strict regulatory control, because you can then show that there's independence and no material connection. So we've got the amnesty, as you know, the time within which to do the expression of interest was previously 30 September. It's been extended to 30 November. I think there's been a reasonable take-up in relation to that. As we know, the amnesty is geared towards payments to contracted general practitioners, relates to the 2018, 2019, 2023, 2024 financial years. I wrote an article recently just in relation to some aspects of the amnesty which I found to be curious. One is that it's only available to general medical practices. So you've got a ruling that has a broader reach than just general medical practitioners, but general medical practices, but for those other members of the industry, you've got an amnesty affording them no protection at all. So you've got to do your expression of interest by 30 November and then make voluntary disclosure by 30 June 2024. The voluntary disclosure stuff, there's an information circular that deals with this amnesty. The voluntary disclosure stuff's pretty vague as to what constitutes voluntary disclosure. So what it says here is to constitute a voluntary disclosure, designated medical practitioners will need to voluntarily provide the Commissioner with all of the information that the Commissioner considers is necessary to properly determine the practice's payroll tax obligations. That's very sort of vague and broad. There's no real prescriptive list as to what precisely you need to give. And then the test as to whether you've made sufficient voluntary disclosure is subjective. It's the Commissioner determining that you've done this. One concern that I raised is what if you go through this process in good faith, you disclose commercially sensitive information about your business arrangements and structure, and the Commissioner turns around and takes the view that it's inadequate disclosure, you're not eligible for the amnesty. The information circular doesn't contain any guidelines about for what purpose the Commissioner might then use that information. So is it intended to be limited to purely just assessing your eligibility for the amnesty, or can it have broader applications? So can it be used to assess a practice's historical liability where they're ruled ineligible, or to scrutinise the legitimacy of the subsequent restructure that you might do to achieve valid legal or commercial objectives? So just some of the concerns that I have around that. Time will tell in that respect. Considerations for medical practices moving forward. So there's various relevant contract and grouping issues to be considered. Obviously, you'd be looking at your contractual arrangements with practitioners to see whether they might be regarded as being relevant contracts, whether there's exceptions that might apply and what your exposure levels are. For designated medical practitioners with significant risk identified, you'd probably give serious consideration to expressing an interest in the amnesty, but that might need to be balanced against considerations such as subsequent restructure. You could give consideration to a restructure involving a redirection of the flow of money, where this is going, as we said, directly from Medicare patient to individual practitioners. Could be a simple and effective way to ensure the payments aren't treated as being deemed wages. I should say, so Queensland's updated its ruling to expressly deal with those issues. It's providing clarity on it. SA hasn't yet. So it will be interesting to see whether that occurs. I mean, there was a pretty big lag time between the rollout of the initial ruling. So whether that does or does not happen remains to be seen. If you decide to look at a redirection of the flow of money, there's then, I guess, commercial considerations for the practice as well by relinquishing control over that fee collection process. So there's then a reduced service offering, there's no security, there's reliance on the practitioners to make payment of the agreed service fee that could have consequent cash flow issues for the practice. So there's commercial considerations to have regard to there. Lastly, you could give consideration to a hard restructure. There's a range of transactional, legal and compliance issues with that. So potential income tax, CGT and stamp duty, if applicable. We also want to make sure we're not vulnerable to attack under any anti-avoidance provisions. So that needs to be carefully looked at and worked through to make sure that it is actually viable. And that's what I've got.
Just a couple of points. With the redirection, well, surely you don't have to redirect them, they're already in the situation where their funds are going straight to their personal bank accounts, they're paying a service fee. Is that basically is that going to exclude them from being caught under this ruling? Unless there are other factors, you mentioned a few about how the clinic holds itself out and all those sorts of things, but is that going to do enough?
Yeah, so at the moment you've got you've got 3 doctors in Thomas and Nars style situation where they're claiming payments directly from Medicare and receiving payments directly from practitioners, from patients. It's going directly into a bank account that they control. They then pay out the service fee to the clinic. The Court of Appeal in NARS seemed to suggest that that's a ready mechanism to avoid the operation of these relevant contractor provisions. You don't then have a deemed payment, and then we've now got some support for that through that reissued ruling from Queensland, which provided clarity around it. So what I would hope to see is that SA follow suit, and there's an updated ruling that deals with the sorts of things that Queensland's recently dealt with.
Sure. Just the second point I had was, is there any talk about where your practices that you've got multiple owners and they receive all of their income through either a dividend or a partnership distribution? Is any of that coming into question for payroll terms?
Not sure whether it's, that sort of structure is, I guess, a sort of structure that one might be looking at if they're considering the prospect for a restructure.
I'm talking about ones that have been doing that for forever.
Yeah,
Structure, it's not a restructure, that is the structure.
Yeah, so there isn't actually any relevant contracts. Then I guess on foot you've got what practitioners that are effectively owners of the business that are conducting the clinic.
And receiving a profit share or a dividend or a partnership distribution.
Yeah, so I think the argument there would be that it's not we then don't have a relevant contract because we're not separately contracting with these people as independent contractors. So those provisions caused issues in the past shouldn't be applied.
Yeah.
That would be exceptional.
That sort of structure.
Yeah.
Right, that's a perfectly usual structure to have, corporate entity or partnership of trust or people.
And then does it have to go to the individual or can it go to a company? So if we were distributing to a company for that doctor, for example, is that then deemed, that third party?
I mean, the third party payment provisions assume that we've got a relevant contract on foot. So the first thing that needs to be worked out is there a relevant contract, and then only if the answer to that is yes, might we become concerned with the engagement of the third party payment provisions.
What about a shareholders agreement?
It's like
Shareholders agreement.
What about it specifically?
Well, is that a contract? So you're receiving dividends under some sort of formula that's driven by a partnership agreement or shareholders agreement. Is that?
Yeah, interesting point, and one that I haven't stopped to think about is the effect of that shareholders agreement that the owners of the business are then providing some form of service to the business under a separate contract. I mean, they're the sorts of considerations that one would have to work through, I think.
GPs wished about to do the personal bank accounts and change the flow of funds. Will that be considered tax avoidance?
Yeah, good question.
We're doing it now just before, and we applied for it. I didn't want to do the amnesty. I had the same concerns that you raised. But thinking about it, the risk of a 5-year, we would just become insolvent, tax burden. So that was one point. The other point was, are there, like us to our actual owner practitioners, we're also working on it. Is our income subject to the payroll tax as well?
they're probably sophisticated questions and probably ones I'm happy to speak to you about
Okay.
offline, I think. I'm
Right.
happy to do it afterwards if you like.
Do you see a difference where you've got the personal bank account, but the service entity or medical practice has a person who's access to those doctors' bank accounts?
No, I mean, if you've got the money, it's a bank account that's owned by the petitioner. So the access to the account might be different as to the owner of the account in which the money's being paid. So it's a good issue, raises some practical considerations, but
Really, just from a control point of view, you mentioned the security risk.
yeah,
You know, if it's part of the role of the practice is to help flow funds, but it initially lands in the practitioner's bank account.
yeah.
I'm just wondering whether the fact that the administrator can control that bank account is relevant.
Yeah.
Or is it just all about the name?
Won't be control, we're looking at a read-only function.
Yeah.
Accounts, so that it can't be controlled.
Yeah, I mean, the practitioner is the owner of the account, I guess would be making the argument that it's just a direct receipt of payment from Medicare and patients, and so who might then have access to the account is beyond the point, but I think there are things that need to be carefully analysed and worked through to assess the risk exposure to that.
In allied health, I'm assuming private health insurance rebates will be considered in the same way as Medicare rebates
Yeah, I
from
would
third
have
party.
Yeah, I would have thought so.
And talking amnesty, I've been working with RevenueSA a little bit recently around this. They still haven't had a reply from the Treasurer about allied health,
Yep,
dental practices, physio practices, etc., etc.
yeah.
Do you know anything more?
No, and I continue to monitor the situation closely.
It doesn't seem particularly fair, I'm going to be honest.
Yeah.
We're up for a big bill.
Yeah, I can understand where you're coming from. As I said, you know, you've got a ruling that's indiscriminate, then an amnesty that's very targeted.
And it's a way of doing business. It's been done for a long time to now change it and not give an amnesty. No, it's not right.
We're happy to change it going forward from 30th June, but
Yeah.
it's just not, it's going to send a lot of dental practices, physio practices under. That's the reality of all this.
General would have done the same with general practice, and that's why they've done this. So they've got to look at the bigger picture. I think.
I think the AMA is a much more strong lobby group in unfortunately, or in South Australia.
I think that might be the point.
Yeah.
I'd just like to thank Daniel for time and effort that goes into these seminars. I know how much time and effort goes in. He's obviously done a lot of reading to get across these issues and obviously on the cutting edge of this issue. Daniel's details are up there. Feel free to stay around afterwards or get in touch with specific issues that relate to your practice. And I know that some of those issues are fairly specific, particularly in the owner contractor situation.